Douglas Benoit. Is there an application or applicant?
Yes, Mr. Chairman, for the record, Attorney Thomas Cronin.
Chris, I didn't realize it was correspondence.
Correspondence, list number 3, received through February 29, 2016, AR 15-219, petition to amend the zoning regulations of Douglas Benoit. February 24, 2016, letter from Richard Roberts of Oliver Sage LLP. February 26, 2016, letter from John Buzowski, CME Associates Inc.
Again, for the record, Attorney Thomas Cronin, Cronin and Shields, 20 Water Street, Connecticut. Thank you for the opportunity to come back in front of you. I think this is my third trip in here. I'm probably getting close to learn out and welcome. But especially I want to thank the Commission for the direction that I got last time I was here. I was granted the opportunity to work with your consultant planner. He was gracious enough to not only work with me, but to work with me in a timely fashion. I actually got inputs and time to respond, and we had a couple of iterations. And what I'd like to do, after just a few introductory remarks, kind of take you through, I know you've seen it, his most recent letter. I'd like to kind of get the highlights, largely for the benefit of the audience, so that he hasn't seen it. Certainly if I misrepresent anything, you're unintentional, I'm sure I'll be corrected. Before I go there, I should introduce Doug Benoit, who's with me from Arista Development. He's the applicant in this proceeding. And again, before I get rolling on the letter itself, the conversation that just took place seems to require that I bring a point out that I think should be obvious, but maybe it isn't. Question from Commissioner Dahlgren just a few moments ago about the character of the application that you just closed the public hearing on is for zone change. And that certainly was an option available to us, one that we chose not to follow. Although depending upon what happens, it may be something we look at in the future. The route we chose to go was to present to you the idea of adopting a set of regulations, a general set of regulations, that would put another tool in your toolkit. And that additional tool would be the tool which would enable you to adopt floating zones. If you think about the difference between a zone change and a floating zone, a fair analogy is kind of a shotgun versus a rifle. Some of the conversation that I heard is familiar to me because I've made zone change applications, I've presented zone change applications in different venues previously in my career. And one of the questions that always seems to come up is, well, if you do it for this zone, we got 5 areas in town that are zoned this particular way. If you do it here, it really makes a lot of sense. But boy, if you do it over here, maybe it doesn't make so much sense. So you got the rule of unintended consequences to pay attention to. The application that's in front of you tonight, my application, has 2 pieces to it. Number 1 is the piece that will enable this commission, authorize this commission to adopt floating zones, period. I don't get mine adopted yet, but the first part is the power to authorize floating zones. If you got that far, I hope that you would consider the next step, which is, because the first floating zone I would present to you, the one that my client is interested in, does it make sense for you to adopt as part of your planning? So that's my attempt, people's attempt to kind of set the stage as to what a floating zone is, how it's different from the zoning reg amendment. It's up to you to decide which is better. One of the features of Attorney Roberts' letter, as I read it, I wish he didn't say it, but one of the things he says, what do you need a floating zone for? You can always amend the regulation. He's absolutely right. But the question that I hope you ask yourselves is, which is the better planning for? Now, turn to Mr. Kuskowski's letter. This is a letter dated February 26th. I do note in here, and maybe it can be corrected on the record, in paragraph 1, it references the New England Village Special Design District, which was the old nomenclature. I certainly cast no stones on that because I'm always editing old versions of letters and forgetting to update something. But the new designation is the Main Street District, MSD 1. But I think that the comments are still applicable. In the first numbered paragraph, the applicant has done a generally very good job of responding to the staff and commission comments. I appreciate that. We tried very hard to do that. The current version is dramatically improved. Regulations are internally consistent. So I think that frankly, that's a tribute to John's commitment and the staff's commitment to feed their inputs to us and work with us to help us get to where we finally got to. So that was a joint effort for everybody there. Number 2, all the organizational editorial details have been addressed with the exception of one. And this is where your consultant planner and I diverge, but don't necessarily disagree. He will speak for himself, I'm certain. One of his significant criticisms of this floating zone is that it does not call for residential uses within this floating zone. I get that. It doesn't. I'm not going to stand up here and say, well, somebody misunderstood or the earpiece didn't work or whatever. It doesn't call for that. If residential uses wound up in this floating zone, there would be no issue. It would not be the least bit troublesome to me or to my client. I will tell you what my concern is as I stand here at 7:45 this evening about putting that in right now. It's a technical concern. I don't know, and I truly mean it when I say I don't know. I don't know whether expanding the uses to include an unadvertised use would violate and compromise the legal notice that we take. So it's a technical concern only. If my concern is accurate and you wanted to solve that problem, if this regulation was adopted, we could come back and amend it after the fact of proper notice. Maybe I'm being overly concerned about it, but that's the extent of my objection. There's no substantive objection whatsoever. I really do appreciate the very last paragraph, the recommendation based upon the set of regulations that the commission consider approving with conditions that include allowing residential uses would consider this approval. So that's as good as we can do at this point. There's no reason why pro-development projects need to be at odds with planning and zoning commissions or consultant planners. And I think here we have come fairly close to putting our interests, common interests, in front of you. The basic changes that are in here, there are a few of them. Some of them are consistency issues. I'll try to give you a quick summary of what they are. There was a section in here before. There's so many iterations of this one, make sure I've got the right one. There was a section in here before that talked about mail notice to like 200 feet. Yeah, there's no point in that not being 500 feet because there's a statute that says that if you're going to change a zone, you've got to give mail notice to anybody, a portion of whose lot lies within 500 feet. You're probably familiar with the term protest petition. And that's where if somebody comes in front of you with a certain kind of application, if enough of the neighbors, actually I think it's a, correct me if I'm wrong on this, if neighbors who own 20% of the dirt within that 500-foot radius, if they sign a petition, it changes your voting requirements. It makes it a supermajority. When I say 20% of the dirt, if you have a 1-acre lot, but only 100 square feet of that is within the 500 feet, you only get 100 square feet of vote. Okay, so So that 500-foot requirement is necessary anyway, so there's no reason not to make that uniform. We did that. We also cleaned up, I think we cleaned up, relying on what John said, we cleaned up one of the areas that Richard Roberts mentioned, and that was when we talked about the process, the decision-making process. I think we cleaned that up, clarified it, and amplified it, because there's multiple steps involved here. And let me try to tell you what all the steps are. I mean, I'm standing here tonight, and eventually you're going to have a such and such a building sitting on a particular site. Well, the first thing I need to do is come in front of you, in this case, with a petition to give you the authority to create floating zones. That's number one. If I get that far, the next step I have to take is to come in front of you and ask you to adopt a particular floating zone. Then I have to ask you to put that particular floating zone on a particular spot on the map. If I get all the way through that, then I come back with a special exception application, and that's where all the really exciting and interesting things happen, like walkways and plantings and parking and traffic and all of that kind of stuff. So I got to get all the way through all of those steps. The way that decisional process was explained in the earlier editions was just not a very good job by me. I hope it's better. I think it's better. I hope it's more intelligible, but it breaks it down and explains what needs to be done. One of the other changes that came out, and this was out of a one-on-one conversation I had with your consultant planner, there was an area in there where we had given more latitude to you than might be warranted or permissible under McKenzie, and that language has come out. You have latitude, but I don't think I need to rub anybody's nose on how much latitude you have and put everybody at risk of being overturned on encroachment on. Those are kind of the big issues that are in there. There's a lot of clerical cleanup. Again, I do appreciate what I consider to be a positive response from John, but I do want to acknowledge straight up out front two things. The fact that we are not proposing we're not proposing at the present time, including residential uses, but we have no substantive objection to doing that, whether it's now or some future time. There's no opposition to that. And the other part is to underscore the comment that, as I read it, both John and Rich Roberts made, which is my translation, why are you bothering to do this? Why don't you just go amend the regulation? Well, that's really not for me to answer that. That's for you guys to answer. I think that the floating zone gives you a far sharper planning tool to use. If you don't think so, then you're going to turn me down. So that's my presentation. I appreciate the time here tonight. I appreciate the time here the last two times. And unless you have questions, I'll sit down and be quiet.
Thank you. Okay, the hearing is now open for questions or comments. I'm going to start with in favor. The same rules apply. Please step forward, state your name and address, and please write your name and address down on the sheet over by Christine. So, anybody who would like to speak in favor of the proposal? And anybody who would like to speak in favor? And last time, anybody who would like to speak in favor? Anybody who would like to speak in opposition?
Good evening. I'm Attorney David Weiss. I represent Core Investment Group, 67 West Main Street, Brooklyn. This principal is Mr. Milano. And there are just a few comments that I wanted to make to you tonight with regard to the current application. Several of those comments I can think seen already in the comments that Attorney Roberts and the outside town planner have made. And I think most of their comments can be really originate from the fact that you have an unusual process going on here with this application. In most towns where the concept of a floating zone is being proposed, whether it's a town or city, you have the municipality itself, through its town planner, making that proposal. Usually after there's been a significant study done in conjunction with a plan of conservation and development, where the town is developing areas where properties and zone lines don't match up. And floating zone concept is a way, without having to completely change your zoning map and incur that cost, to have these zones you could basically overlay and plop right on top of a much larger area, and allow for a consistency of development in that area, where you have areas that are changing from commercial to residential, or residential to commercial, or commercial to industrial. So it is a very unique tool for a very specific purpose, but it's usually coming from a policy-making place. Here you have an applicant, through no fault of his own, has a series of properties that may or may not be difficult to develop as a unit. And so the applicant is putting forward this floating zone concept in order to try to make his single or multiple parcel development possible. The problem with that is you have these two contradicting forces at odds with each other. One of which is a town-wide policy argument, and the other is a specific property owner argument. So when Attorney Cronin talks about the outside town planner's comments in his correspondence of, well, I'd rather see residential uses incorporated because our plan of development that we've recently adopted talks about mixed uses. So we want to promote those mixed uses. So not incorporating that residential use within this floating zone concept is in direct conflict with your plan of development. Because in your plan of development, you've made a policy decision that says, we want to see commercial with residential in this central town area, in this village area, so to speak. I know from experience in how difficult it is to do that kind of development, because that's exactly what Core Investment Group did at 67 West Main Street. And it had to be in a labor of love because it required so much effort going through Zoning Board of Appeals, obtaining the requisite variances, going before you folks, getting the special exception approval, getting the specific development approval, then having to go back to the Zoning Board of Appeals when there became a traffic issue. So he understands the difficulty associated with having to go through that process, but he also appreciates it because he came out with a development that everybody loves. And so that process worked. So why change that process? And the problem with the floating zone as it's been proposed is not that it conflicts with this plan of conservation and development where you've made a policy decision, is that you're now restricting that floating zone to 3 specific zones, okay? Now, the first of those zones is the I-1 zone. And if you look at the zoning map, the I-1 zone basically runs from the town of Madison border on the south side of Route 1 and ends before you get to the central part of town. And if you look at the parcels, you'll see they're all significant parcels of property. There are very few small parcels of property that would be affected by this floating zone, or that anyone who owns those properties would want to utilize it. And then the other two zones are the B2 and B3 zones, which are the small blue, two small blue areas and one magenta area that are right in the center of town. And that's where Mr. Milano had to do his development. And it's where you have these intersecting areas of residential and commercial use. The problem is that if you limit a floating zone to just these two business zones, why have a floating zone? And I think that's the question that Mr. Roberts, the town's outside attorney, is asking in his correspondence. In other words, if you're restricting the areas so much in which this floating zone can be utilized, why not just look at the B2 or B3 zones themselves as far as adding a requirement, subtracting a requirement, and just looking at your commercial development within the zones you already have? Why adopt this overlay zone that isn't going to add anything to the mix? In fact, it's going to take away the residential component to the mix that you in your own plan of development want to retain. Okay? So I think that's where the main comments are coming from. Now, there are more specific issues that they both raised. Well, how do you get to this 60,000 square foot requirement for a minimum lot size? That's only an acre and a half. When you look at other towns that have adopted these floating zones, you're looking at much larger territory. Okay? You're looking at a city who doesn't want to go neighborhood or town, go neighborhood by neighborhood and redo their zoning map. And so they create these large swaths of area, whether they be 10, 15, 50 acres. You see them in some of the municipalities. New Haven has adopted it in their charter, an overlay or floating zone concept. And it took a fight all the way up to the Supreme Court that I happen to be involved in to get that adopted in New Haven. The problem you have elementally is you have an applicant that's seeking to accomplish something for its specific purpose. And an acre and a half fits its model. But nobody's looked on a town-wide basis to see whether that fits the model of everybody else who may be in a B2, B3, or island zone. So when Attorney Cronin talks about the law of unintended consequences, you now have a tool that an applicant can use, not include a residential or a mixed use, okay, and is only restricted by the commercial uses it can envision. And looking at the plan of development, that's exactly what this town didn't want to do in these central town areas. It wanted to retain this mix. And what this floating zone does is it allows you to restrict that mix. It allows you to basically create this floating zone concept that conflicts with your own previous public policies. So those are kind of the overarching comments that I have. There are issues with that the outside town planner and the town attorney have raised with regard to the integration of this zone with the other already existing zoning regulations. I think there are a lot of minor issues like that have been raised. But I think the overarching issue is that Attorney Cronin, through the best of his efforts, is trying to put a square peg in a round hole. And I just don't see, and my client doesn't see, what it adds to the process. Not when you have someone who has gone through that process, worked through that process, didn't require an overlay zone to do it, and achieve the development that everybody in the town wants to see. So I think that you have the tools within the existing B2 and B3 zoning regulations to do what this particular applicant needs to do. And I think you heard him acknowledge that this isn't the only solution for them. This is the one that they would prefer, okay, because it creates the broadest swath of area for them to accomplish their development in. But it doesn't achieve that development in the context that the town's regulations currently want to see it. There were issues with regard to, okay, they want to put a big CVS there, and nobody wants to see a big CVS there, and the traffic issues and the parking issues and all those kinds of things. I think the broader question is the one that's being raised by the town's own consultants. And that is, this really isn't a concept that's needed. And I think that's what you should really focus on. And that's why we stand in opposition to the application. Thank you.
Anybody else in opposition?
Thank you.
John Olson, 101 Pratt Road. The previous speaker actually kind of addressed some of the areas that I have concern with. And I was going to ask the question, you know, with the other development down the streets and the other developments, you know, why do we need a floating zone? So I thought that process, you know, has worked for us in the past. We have a planned development, we have zoning regulations, people come in, and they can work through that and obviously develop property. I spoke with an attorney who represents clients down in Stanford. They do have a floating zone. And I asked him about it. He's been on it for over 30 years, and he told me, again, similar. It was, you know, they were looking at it for big plots where they would drop it in. But he wasn't too, you know, his answer to me was that he wasn't too high on the floating zones because he said, you know, I'll probably get in trouble for it, but he says it ends up being spot zoning, and that's, you know, what the concern was from his standpoint. So I think we can develop, we can have nice developments in the town, and people can work through it. It might be a little bit of work. Anytime you want something good, and that's going to be good for the town, good for the developer, that a process has to be gone through. Because, you know, the process starts looking for other ways to make it easier. For whatever reasons, if you can do something within your zoning regulations and your, you know, your current zoning, I don't understand why, you know, we need a floating zone. I still haven't been convinced on that, so I'd like to just speak in opposition to it. Thank you.
Vince Semino, 26 Old Mill Road, and I want to go on record as saying that I'm completely opposed to this proposal and to this application. This is clearly spot zoning, and spot zoning by definition, if you just read into the opinion by Halloran and Sage, is really anything that's under 10 acres or around 10 acres. Stanford and any other town that in this area that we've looked at requires a minimum of 10, 20, or 50 acres in some cases. And in the Halloran and Sage opinion, it specifically addresses the recent Madison case for the Madison Hotel, and it calls it spot zoning. Why? Because the particular area that the hotel is on is very small. It's not a 10-acre parcel or 20 or 50. So this is something that an applicant has hired an attorney to try to find a shortcut, and that shortcut is not only inappropriate, but it would have some severe repercussions throughout the town. So it's wrong, and if you approve it, it's probably, there are attorneys sitting in the audience right now representing residents. This is probably going to be appealed, and based on this opinion, which is your own consultant, which would be used in court as well, you know that this is spot zoning. You know that the area that's being talked about for this CBS is too small, and so I ask that you deny it.
Hi, I'm Pam Fritz. I live at 1404 East and I've been on the Planning and Zoning Commission previously for many years, and I'm sure the commissioners do. I just think that, and I think that Attorney Weiss was very eloquent in how he put it together into indicating that you're sort of, this is one applicant who wants to go through this and use this whole floating zone concept for the entire town. I think you're mixing two things together that should not be mixed, it should be considered. And I did consider it that way, and I'm speaking in opposition, obviously, to the idea of a floating zone for the entire town. I did some homework, and the homework I did was actually, I looked at the regulations in Madison, and I'd like to submit this to you. Madison has a very excellent way of approaching this. And they have what they call the floating design district. But the specifics that you have to go through to be able to get one piece of property to comply with the petitioning of getting that property approved is very, very, very complex. When I say complex, it's thorough. And it mentions how we're following the plan of conservation and development in the town of Madison. It mentions a lot of specific things that I think would be very helpful if you're considering doing something like what is called a floating design district. Incidentally, the judge, and I can't think of his name right now, who wrote the book on the conservation, made a comment in the beginning of his of the book. He said that the floating zone concept was popular in the 1960s and the 1970s, but it's not as popular anymore. And so my feeling is, why would the town of Clinton want to go back to something that was a popular concept in the 60s and the 70s? I think what Madison has done is an excellent thing, and I'd like to just...
Can I ask you a question?
No, you cannot ask her a question.
Okay.
That's not what we're doing.
I just wanted to know.
You can ask Mr. Cronin a question.
Is there anybody who can say this? I'll just give it to you. All right. But I am opposed. I think that it's a separate. This application has to be the application that the client that Mr. Cronin is representing should be doing its application in the entirety of what needs to be done, not to do it as some part of creating a potentially by the attorney's own comments, potentially other problems by a blanket on floating zones.
Ms. Fritz?
Pam, Chairman, let me have permission to ask you a question.
Oh.
What was the acreage for Madison for the floating zone?
The way that document is written, you will see, it actually takes it on a case-by-case basis.
So there's no minimum, no maximum?
But it has to conform, again, to policies that have been set up regarding plan of conservation and development. It has to follow very, very strict guidelines. And a petition to do something like this requires a complete site plan, requires all the traffic thing, all of that has to be done before you can even go forward to say we want to create this floating design thing, what they call it something different, they're getting it wrong. So it's just a whole different process, but it really protects the integrity of the town's plan of conservation development and follows some very, very good guidelines. And I'd like to see us look into something like that. I think it'd be very
Thank you,
constructive.
Mr. Chairman.
Anybody else in opposition? Anybody else in opposition?
Yeah. Jeff Cashman, 66 River Road.
My first concerns about some of this was the limitation to the zones that you have, period, on this application. I want to remind the commission in making your decision that there are businesses located in the residential areas also too, and the right to free enterprise should be covered through all of those. And I wanted to mention the agricultural purpose that's allowed in your residential period. If Jeff Cashman owns 58 West Main Street, which is a B district, I also have the right to a free enterprise on my farm, which is a business also too. So to limit my right to free enterprise and give me privilege on one entity and not another entity doesn't seem quite fair. When everyone in this room has a right to be able to have a farm operation in residential pieces of property if you have 3 acres or more. I wanted the commission to take into full consideration, if you do go through this, is to make not only the B districts in the industrial issues, I'd like to see it cover all districts in the town in case there's a farmer that would like to be able to take a residential piece of property, maybe live on that piece of property and then have next to it the industrial, say, for example, today we have an industrial site, the bakers have an industrial for their house that's there, but yet they have residential that goes on top of their residential farm operation that's there. If they wanted to, being residential and wanted to be in the industrial, to be able to cover that floating zone and maybe turn it either into residential or turn it into industrial, this floating zone could be applied for under special exception. So to limit those home occupations, which are businesses, or to limit farm applications, we need to take into consideration that there's farmers, 121 farm operations in this town also too. So that's where I speak in opposition. There was an opposition, or there was clarification that the commission had under special exception for all zones to be able to be reworked for the better of the plan of conservation development or for some other opportunity. I can understand it. So tonight I want to officially speak against it because it doesn't have any residential involved.
Anyone else in opposition? And last time, anybody else in opposition? Moving on to general comments and questions. Does anybody have a general comment or a question?
Here, I'd just like to address the question about Madison. And
You need to stand-
I'm sorry?
you need to stand up.
Oh, sorry.
The tape just doesn't know who's speaking.
Sure, Vince Amino again. And Madison, this is the first time that Madison had ever granted a floating zone type of application, and that's why it was taken to court. And the judge ruled that it was not proper. So I just wanted to answer that question.
Any other general comments or questions? And the last time, any more general comments or questions?
My question is, Hank Stein, 6 Mohawk Drive, Clinton, Connecticut, 06413. My question is, why is the commission even considering this? The attorney says it gives you a new tool. From what I gathered, what I've heard, it just puts one more level of problems of getting anything approved by this commission. In addition, if you have a floating zone, then they supposedly have to come to the commission anyway. So why have a floating zone if you still have to go through the same process? It seems like we're just making things much more complicated than they need be. I talk to people that do have businesses in Clinton, and they already are finding a great problem to do any business in Clinton because of all the rules and regulations. So why add more?
I can answer a couple of those questions for you. So the first in the process is that anybody can come before us and request a regulation change. And I think it's my opinion that anybody who does come before us, if it is deemed to be in order, meaning their application is in order, they deserve a public hearing on whatever they would like to do. There's been a lot of testimony tonight that the applicant may, is trying to kind of use his tool the way he wants it. It was actually the town who recommended that this may be an avenue that they can into. So it was land use that actually asked the applicant, maybe this is a way you want to go. They gave him, I think, several options, and this was one of them. So it's certainly something to explore. It may be a good tool. It may be that the commission decides it's not a good tool. But the purpose for the hearing is to decide whether it is or it isn't. After this hearing is over, if it is closed, it'll move to our regular meeting, and somebody could then make a motion to either accept it or deny it at that point.
When I've sat through these meetings, this is the third one. This is the first time it's mentioned that the town proposed this, not the very valuable lawyer. And again, I'm not in opposition, I'm not in favor. I just question why this would even be considered.
As I explained, just
And
to be considered, that's why we're here tonight, to answer that question.
Still under general comments,
Please come forward and state your name.
I wanted to just caution the commission also too that in making some of these regulations, there are many regulations that are here. I'm going to start off with the very first one in your zoning regulations, that it says anybody who violates these zoning regulations is penalty under law, lawsuits, all those things. To make the zoning regulations so that everybody can understand them. In watching this hearing, I've watched attorneys go, I want to be able to turn this word here, I want to twist this word here, and I really sometimes watch the confusion of the regulations to where people don't understand them at all. And to have people get up and say, I don't understand the regulation, and to have everybody accountable for those regulations with a violation of cease and desist order, all those other things, make the zoning regulations simple enough so that the average person can understand them. When you have the intelligence of attorneys that know law, sometimes people need to understand that to be in violation of these zoning regulations that you set forth, they have to be clearly understandable to the average person. And to get so complex that you take something out of Part B and to Part C to refer over to this, or it just gets really confusing for the average person. And I really wanted to caution that if you can simply make the zoning regulations be so that your average person who reads the zoning regulations as they're applying or doing research, that the average person should be able to come in and make their own application and not have to have the expense of an attorney come in and be able to do that because they're so complex that nobody can understand them. Now, Eric is a really smart guy. He's got a great college education and everything else, and he's working with people here. But your average person like Jeff Cashman or these folks or some of these other folks in the room, they really just don't understand the high complexity of some of the zoning regulations to their full effect. And that's what I really wanted to say in just general comments, to make them so that everybody can understand them so that they're black and white. It's kind of like your kids saying you only have 3 cookies. You know what I mean? And they say, well, if I take the Oreos and split them in half, is that really 6? No, you're allowed 3 cookies. That's the way it is, you know, so that's the way. But that's the comical part about it is I just didn't want to see them be so complex that people can't quite understand.
Can you just state your name?
Jeff Cashman.
Thank you.
You already said it, thanks, Jeff.
Okay, any other questions or general comments? And last time, any more questions or general comments? Okay, I'm going to open this up to the commissioners. Do you have any questions for Mr. Cronin?
I have a question, Mr. Cronin. Ms. Fritz has referenced the floating design district in Madison. Are you familiar with that?
Very. Can you go through and explain to us the difference between the proposed design district and your proposed amendment? Oh, at this moment in time, there's no difference whatsoever. Can I see that exhibit, by the way, if I can just...
Like right here.
According to the exhibit that was submitted, I have no reason to disbelieve it. I think it's about right. It was approved in April of '06. And Ms. Spritz commented that Judge Fuller in his treatise talked about floating zones going out of favor in the 70s. So 35 years later, Madison adopted the regulation. What I said was there's no difference between that regulation and this one. In this sense, Madison has never approved a single application under this regulation. Madison has never received, in 10 years, an application under that regulation. If your staff talks to Dave Anderson, the Madison Town Planner, he will tell you that that regulation is so unwieldy that do everybody a favor and just turn me down. Don't waste your time asking me to adopt this and give it to you because no one's coming up. It's about a $150,000 application to come in. So I am very, very familiar with that. Madison has a bunch of other floating zones, a bunch of other floating zones. Madison happens to do all of their affordable housing under floating zones. And those are brought in by applicants, not by the town. So the specific answer is, yes, this was adopted. It was adopted in 2006. It was amended in 2010. But not a single application has ever been filed under that regulation.
Anybody else?
I just want to touch on the issue of residential. Having worked on the plan of conservation development, many of the areas that a floating zone potentially cover would fall under the residential imperative that this town is looking for. We're looking to increase our taxes. By doing that, we're looking at increasing jobs by putting more density in certain areas. And the only way we're going to do that is taking some of the areas in the downtown, which is considered transit-oriented development, and incorporating residential into those areas. So taking any floating zone that's going to cover any of the B3, B2, that is in our downtown, and I couldn't see any application coming in without that residential component at this point, having it comply with the plan of conservation development.
Yeah, if I can respond to that, and frankly that gives me the opportunity to respond in part to Attorney Weiss's comment. My reading of John Guskowski's letter, my reading of it, is that he agrees with that. But I think, and he's here to speak for himself, so I don't have to do it, but I think a fair reading of his letter is that if you're going to consider approving this particular floating zone, which is the second question, the first question is, are you going to consider any kind of floating zone? But if you're going to consider this one, his position is that in order to make it more compatible with POCD, that residential uses ought to be included. And if I didn't make it clear on the record, the applicant has no objection, no substantive objection to that whatsoever.
I just had a quick question. Apparently, one application at this point, one application includes both the concept of floating zones and the particular sort that you're proposing all at once. There's two separate applications.
That is correct.
Allow.
I believe we have the option of voting on it still as two separate applications?
Well,
Two different parts.
with pieces, you can approve pieces of it and deny pieces of it. It's coming under one application, though even under one application, it does not land the zone. It puts the zone in the book. So there would need to be a separate process to land the zone.
That's not a three-part process. One, enable floating zones in the first place. Two, define a particular kind of floating zone. And three, put it somewhere.
Yes.
And this is for private, too, although not regulated.
That's correct.
One thing that I see about the Main Street district, zoning district, we talked about it being Main Street oriented. There's nothing here about design standards that include multi-level. Almost required for it to include the housing component that we're talking about.
No, that would be not on the road. No.
Well, I mean, in definition, it would be more probably the Main Street district.
I'm not sure I understand your
It says-
question or comment. Is that-
Let me see if I can
Is
find
that
it.
there should be a design standard at
Let
this
me
time?
see before you, I'm looking for the place where it is.
I think you're referring to it being a stage
The
one.
area bulk and height, we talk about a maximum height for not a minimum. This is page 2108.
You need a minimum, or could the minimum be passed before? I'm sorry. You're saying the minimum might be 2?
For a lot of Main Street districts, we define, to avoid getting the strip mall.
I think you're sort of referring to things, the design,
It could be a
Standards.
separate down the road.
similar to something in the IBZ zone, something more specific.
It's we're talking about maximum height, we did not define a minimum.
But I mean, in my opinion, is that in these public hearings, we keep getting stuck on the same point, especially when it comes to special exceptions. One of the reasons to have those items in a regulation that doesn't have a special exception is that there's no special exception. We don't have the chance to say it has to be 2 stories or it has to be 1. One of the things I like about special exceptions is that we get to, without the regulations telling us that we have to, we can say we don't want a single level 1-story strip mall. We currently have regulations in place that might do things that we actually don't want, but because it's the current regulation, they actually conform to it. Again, my opinion is that in terms of special regulations, a lot of these questions that we bring up may be the cart before the horse. One of the questions I have for you is, or actually for Eric, or for John, that you're not opposed to the residential issues put out there that that's what it was going to be. Is the only option for our group to amend this, or can we, even though we didn't put it out that way, can we put it in?
I guess what I would say is, that issue as to whether it's too broad for the existing legal notice, probably yes, or Rich Roberts as opposed to, your legal counsel should give it to you. If it's his opinion that the legal notice did not cover that, then you've really got 2 different ways of handling it. You can approve it without it and then immediately go back and seek to re-amend it. You can't add it in now and have it covered by the original legal notice. You can either re-notice the public hearing, or you can approve what you have and come back with an amendment. But if it's broader than your original legal notice, you can't just act now under the original legal notice. That's going to be invalid. Whether it in fact is too broad is a legal question you should probably ask your attorney about. Okay?
I just let the record show that Carl Neary has left the room momentarily. As Julie, our clerk.
You need a motion to make that inquiry upon
Doesn't need to be a motion. We can certainly just create.
John, do you have an opinion on that?
I wouldn't have a legal opinion on it.
Even if you close the public hearing, your legal opinion from your attorney can still come in afterwards. If you decided that you couldn't amend your motion later to do that, at that point your choices are deny the application approve it as is and come back with an amendment. So you could still, you could either leave the hearing open to get the answer, or you could close the hearing and get the answer after closing the public hearing. As your expert, as your staff, Rich Roberts' opinion could come in after closing the public hearing.
And the amendment could be the applicant or the,
It could be the commission or the applicant coming in with an application.
so if we were to approve this and the applicant said, well, we don't want, after all, we don't want to do it, we could ourselves come in and say, we're going to.
Absolutely.
Yeah, Mr. Chairman, the attorney brought up, and I'm not supposed to talk about site specifics and all this is written down, but he brought up site specific.
As much as you can stay away from site-specific, try, go ahead.
Okay. And I just,
Hold on a second, John.
Mike,
You can let him finish, I mean, he said he was done.
No, he's not.
Mike Milano.
What is it?
Huh? There was an individual in town that went through a great deal of process to get his property developed. And it seems to consensus of a lot of people that without going down this path, will that area, can that area be developed for the betterment of the town to bring in the monies without going down this path? This one, I want to know if that can be.
It can, but I think one of the reasons that the staff, and I'll let you develop it, because of the testimony we heard tonight about how many hoops they have to jump through just to get a basic small development put in place, this would be another tool that, had it existed, perhaps prior applicants would have used the tool. I don't know if the tool is a good tool or a bad tool, but I think that was the theory of one more tool.
Okay, with the land use office, our town planner, in this commission, want to move forward with the plan of conservation and development, and if everything is applicable down in that area, can we get this thing, can we get that process?
That's going to be up to the commission. We'll have our discussion.
Can I be clear about the application, Earl? You're talking about a specific type of development that's taken place in the Clinton Center area. The previous applicant, Mike Milano, created a specific type of development that went through a lot of processes that were labor intensive for him to get the outcome that he ultimately wanted. This application is a very different application and wouldn't give you that outcome. It doesn't include residential, it doesn't include the same components.
Well, we would want, that's what I'm saying, for that, the process that you mentioned his name went through, and in this area, we don't, it's not going to be residential. It's going to be commercial.
Well, remember, the applicant is not opposed to it being mixed use. It just
Correct.
wasn't advertised.
It shouldn't be mixed use.
And that may be something we want to discuss.
I've never
when we
seen,
deliberate.
I mean, this is not New York, I've never seen, I'll be honest, any CVS with a big, apartments on top that you got the water on and flood out the building, I'll be honest. So, I've never seen it. But not that site. Good.
It's not that regarding a specific site, it's in the zone that we created, which is the Clinton Center
But
zone.
you could do that across the street.
I just caution you, this is probably a great discussion. We can deliberate on this, but for now, try to get questions answered from Mr. Cronin respectfully. One of the questions
Is it funny, Joe?
One of the things sure. Oh, sorry, John. Let the record show that you were back from Carl.
For the record, Tom Planner, planning consultant John Guskowski. I'd just like to point out in the original legal notice posted in the Harbor News, December 24th, 2015, December 31st, 2015, this public hearing was noticed as petition to amend the zoning regulations denying addition of section 21 floating zones, allowing floating zoning generally in the town of Clinton, and setting forth procedures for their adoption. The application would specifically allow the creation of a, quote, New England Village Special Design District, unquote, a mixed-use zoning district, available only to properties presently zoned either I or B. This is my opinion that mixed use is generally understood to mean a mix of residential and non-residential. So it would be my opinion that you have already advertised the potential of residential in this floating zone.
So does it claim that it wasn't re-advertised that way? Or is it the same advertisement?
For the record, Attorney Tom Cronin, I wasn't making a claim so much as I was trying to warn you about stepping on a potential landmine. And I think Eric kind of raised the same issue about going to Attorney Roberts to get his take. But thank you, John, for refreshing my recollection about the notice. If the notice talks about mixed use, I won't speak for Rich Roberts, but my guess is he'll tell you that was broad enough that if you want specifically included, that probably would be no problem, but I'm not your counsel.
So how would we do that tonight if it was advertised that way? Can we just ask that?
Yeah, what you can do is, if you close the hearing, if you want to close the hearing, and then you have Rich give an opinion as to whether he thinks that legal notice is sufficient to cover residential as well as commercial uses as part of the application.
Fair enough. This question for John real quick. There's been a lot of testimony tonight using your name. And I'm a little bit confused. I'm a little bit confused because the testimony is in conflict of what you actually wrote. Because your last line says, my recommendation based on this set of regulations would be that the commission consider approving the proposal with conditions. Do you want to speak to that or not speak to that?
What's your question?
Do you still believe this, I guess? There's been a lot of testimony tonight to the contrary. Okay. Thank you. Anybody else? Anybody who hasn't talked as much as maybe Eddie or Christine?
I just want to clarify what we talked about the last public hearing. We were talking about separating the application into two applications.
It wasn't two applications, two parts.
You can vote on them.
The reason for that was that we thought that one of them may not be ready, and the other might be ready. So I think the thought behind it was we could approve one, get that pushed to the side, and then focus on the other. At the meeting, it kind of, the applicant actually asked to continue. I think you asked to continue at least twice. So that's where that came from. It's up to us how we want to vote on it. We could vote on it all as one, or we could separate it. That would be.
All right, I just want to clarify, because we had discussed it the last time. I wasn't sure when we left it this, coming to this public hearing, whether or not the applicant was still looking for that direction or.
Okay.
For the record, Tom Cronin, the applicant is hoping that we'll get a vote on both elements. But I certainly understand the mechanics and practical benefit of doing it in small bites, so that's not my fault. If I might just offer a few closing remarks to kind of respond to some of the testimony that was given, and I appreciate you asking Mr. Guskowski to clarify what his letter said. A couple of statements were made that I think I needed to respond to because I think that, again, the record may have been mischaracterized. I find the word spot zoning in Rich Roberts' letter. I don't find where he says that anything under 10 acres is spot zoning. He talks about how floating zones have, in a lot of places, been fairly large zones, and mentions 10 acres there. He mentions the Madison case, which I was part of. I mean, but as you know, Eric would tell you, and as Attorney Roberts would tell you, sometimes you get strange decisions. Judge Fuller, who's been referenced here tonight, takes the position that spot zoning is an anachronism. I can't give you the citation, but you've got Fuller, you can look it up. The concept of spot zoning is an anachronism. The fact that you get a judge who makes that finding in a zoning field, sometimes you draw a judge who it's a decision you have to scratch your head on. So I don't think that it's spot zoning in any way, shape, or form. The Madison regulation, although it's never been used, doesn't have a size component. For what it's worth, I mean, about the size is critical. You think, God knows it's big enough. You think that it put area in there. With respect to Attorney Weiss's comments, and I appreciated the way he came at this, I think a lot of what he says, had to say, I would agree with. In a lot of cities and towns, zoning amendments are generated from the land use department. They tend to be larger municipalities with larger land use staffs who can afford full-time people, consultants, and so on to do the work. I sincerely appreciated your putting on the record the fact that the idea of a floating zone was floated to us. We grabbed it and ran with it quite willingly. I don't want to displease anybody. But my client was more than happy to do the work to put in front of you the opportunity to think about adopting floating zones if you think it works. From what I heard in the prior application that I've listened to now 3 times, I think you ought to consider whether floating zones are a good idea. If you get past that, then you get the second question. If you get past the first part, which is do you want the power to adopt floating zones, then the next question is do you want to adopt this particular floating zone? And then the question is, where does it land and what does it look like? But those are future hearings. So, and the last thing I want to say is this, because somebody brought up the issue of an appeal. I always hate to bring up appeals when I'm standing in front of the board, because the word appeal is a charged term, and it always suggests a threat. So let me tell you a little bit about appeals. The application that's in front of you tonight is a zoning amendment application. And the importance of that is that it asks you to act in a legislative capacity. Basically, you act in 2 different capacities. I think you all know this, but I'll put it on record anyway. Sometimes you act legislatively, and sometimes you act administratively. Legislatively, you pass regulations. Administratively, you make decisions. When you act legislatively, the courts, which normally give a zoning commission pretty broad discretion anyway, there's a great deal of deference paid to what the local zoning people say. On top of that, when you act legislatively, the courts take an even more hands-off approach. You're in the best position. You might make good laws or you might make bad laws, but it isn't for some judge sitting in Middletown to say, well, we think that's a bad regulation in the common plan. It can happen, but I don't think that you need to be afraid of an appeal. And I want you to pay attention. I don't think you need to be afraid of an appeal. Whether someone else or whether I bring it. All right? I mean, I'm playing open kimono here. What you decide to do is probably going to stand up. I might not like it, but you don't need to be concerned about it. Okay? So I thank you very much for your time.
I thank you, Mr. Cronin. And one thing I do want everybody in the audience to know is that we generally ask the applicant to come in with the regulation. So generally, in Clinton, it does, most of the regulations are not going to originate with land use. We're generally not going to write the regulation. It is our policy that the applicant writes the regulations, we review the regulations, we send them regulation to the planner for consultant, we send it to the lawyer for consulting. We have a regulations committee, they are reviewing regulations. Every once in a while we do bring a regulation forward, but that is generally how it works in Clinton with very small resources, 2 people. So just want to be transparent for everybody to understand how the process starts. I mean, you saw it, you see around Marina with the son of the owner bringing the regulation forward. So it's everybody across the board. Do any other commissioners have Any other comments or questions?
Here's my only concern is whether or not the application, the second, what's called the second portion of the application, not the mechanism of enacting floating zones with the second portion. When you look at other floating zones that have been created around the state, they tend to be have much more teeth in terms of design standards, so you get the outcome that you ultimately want. And I'm just wondering whether or not we need to have more specifics in this application. We had talked about, somebody had mentioned that we had, this commission had an interest in floating zones earlier on. To my recollection, I could be wrong, I believe we were looking at overlay zones, which are different mechanisms for the interchange zone, and that did give you a better ability to look at the design criteria for that area. We never pursued that. We were able to rezone the whole interchange development zone and get what we ultimately wanted from a regulation standpoint. So, like I said, I feel as though we need to have more robust application in terms of design to know what we're going to ultimately get. Because the certain zones, B4 and B3, have that design criteria built into it already, and whether or not we get it out of a floating zone, I'm not sure.
Did you relay these questions to the applicant or John? When we asked related questions?
Yeah, I brought up the first public hearing about design standards for it.
Anybody else?
I guess the other issue is whether or not we take the vote on just floating zones in general. I think that instead of floating in boats now.
I think there's some kind of... We'll be able to deliberate.
Right.
I can't take any testimony.
Can I ask a question?
I can't. Only because it's not my choice. We'll close that portion.
Mr. Chairman, what about comments that were made after we were given an opportunity to speak? Because obviously,
Mr. Semino,
This was
the
self-serving.
public portion is all done. Anybody else? I would just like to mention before I ask for a motion, entertain a motion to close the public hearing, that there's a reason we asked 3 times during the public portion. And this isn't necessarily the way the chairman runs the meeting, what I'm obligated to do. It is very important during the public portion of this for people to speak up. I know it's a little awkward sometimes when I say this is the 3rd time or this is the last time, but this is exactly why I say it 3 times, so that we don't get to the end and then somebody wants to comment again. So I apologize.
Well, they continue talking, so then they can think of a question to ask. I don't think this is very fair.
It's just the way it works. I'm sorry, Brian.
Mr. Chairman, I just have a question for you.
What should I do?
If you, it's up to you, take the question, take the question. If you-
I'm not going to set a precedent at public hearings of going back and forth and back and forth.
I just had a question for you.
I'm going to say one more time, the public portion ended.
May I ask you one question?
Motion to close the hearing.
Okay, do we have a second?
Second.
Any discussion?
Just ask the question again, do you want to consider closing the public hearing on the first portion of the floating zone application and leaving the second portion still open, as was discussed before?
Make a motion to close over.
Your motion was to...
Your motion was to close. You would have to agree to amend your motion.
Would we be able to act on the 2 parts separately if we close?
Yeah, absolutely. You can act on the voting laws.
It's big. I second it.
Okay, any other further discussion? All in favor?
Aye.
Against? Abstaining? Okay, motion carries. Would somebody, I'll entertain a motion to adjourn?